We've got the decision from the Court of Appeals in the Home Depot case. If you've been watching the news with Mr. Pipsqueak, then you already know that on March 17th, 2026, Judge Carlton H. Jones III heard arguments that Elder Freeman should be immune from prosecution because he was acting in self-defense during the infamous Toccoa Home Depot police scandal. Jones shocked the crowd by denying the motion, giving his opinion that the people of Stevens County do not have a right to flee or resist an unlawful arrest. Freeman's lawyer, Brock Johnson, appealed the ruling to the Georgia Supreme Court. There's nothing surprising in Johnson's motion. He tells the same story we've been telling for over a year now, making numerous citations to Glenn v. the State, Georgia's 2020 Supreme Court decision, in which they ruled that defendants do have a right to flee and to resist an unlawful arrest. Assistant District Attorney Suzanne Boykin's response isn't particularly surprising either, since she just mostly rehashes the same arguments she made in the immunity hearing. But what is a little shocking is how callously Suzanne Boykin lies. Her response contains several claims that are directly contrary to evidence that was presented in court. So before we get to the decision, let's take a look at Suzanne Boykin's 5 most obvious lies. Lie number 1. Boykin wrote, "Petitioner began backing his truck up while Deputy Nelson was behind him." Guys, we've been over this. You've seen the video, Suzanne's seen the video, everyone's seen the video. Dondi Nelson was not behind Freeman's truck when Freeman backed out of the parking space. There's not even any point in beating this dead horse anymore.
And you were aware, believe that he was behind you?
He wasn't behind me. Nelson was not behind my vehicle, and my vehicle never went in Nelson's direction. You know that.
Lie number 2. Boykin wrote, "Deputy Nelson observed petitioner fail to stop at a stop sign." No evidence presented in the hearing suggested that Freeman had run the stop sign prior to Nelson turning his blue lights on. Boykin made that claim in court, but Nelson didn't take the stand to testify to it. Freeman flatly denied the claim, so the evidence presented in the hearing shows that Freeman did not run the stop sign.
There is a street called Memorial, and there is a stop sign there exiting the Home Depot parking lot, and I can tell you for certain that I did stop there.
Lie number 3. Boykin wrote, "Petitioner began his flight without knowing the reason for the initial stop." Come on, Suzanne! Everyone knows why Nelson stopped Freeman. Here's Nelson literally running to his patrol car to chase Freeman down when nothing had happened except for speech. Nelson admitted that this was because of speech.
All it is, I came out of Freeman Home Depot. I walked in Home Depot.
10-4, just hang up so you can quit yelling. Maybe you can hear me.
I did not hear profanity.
No threats, though?
Not that I'm aware of.
Suzanne Boykin herself formally charged Freeman with speech crimes, but now she's saying he did not consider that the stop could be made for other reasons, such as failing to stop at a stop sign, for assaulting an officer by backing up towards him, or for equipment violations, such as a tag light violation, window tint, or any number of other reasons. Suzanne, I'm pretty sure that Freeman's truck didn't have a window tint problem. In reality, Suzanne just gave the whole game up here. She's admitting what we all know. Police just do whatever they want and then pick a made-up reason after the fact.
What crime did I commit that initiated the stop? Name it. Name the crime. You can't, because you know there isn't one. You can't name the crime because you know there isn't one.
Lie number 4. Boykin wrote, "Petitioner struck Deputy Nelson's stationary vehicle." Okay, this is clown world stuff. Deputy Nelson intentionally pulled directly in front of Freeman with the intent of boxing Freeman in. He hit his brakes 1 second before impact. That is not what anyone means when they use the word stationary.
Nelson pulled his car in front of me with the intent of causing a crash, and he did cause a crash.
And finally, lie number 5. Boykin wrote, "Petitioner used deadly force." If that's the case, then someone did a really bad job of burying Dondi Nelson's corpse, because I personally saw him, not dead, walking around at the Stevens County Courthouse. But let's not misconstrue Boykin's claim. In the law, deadly force refers to force which is likely to cause death or serious bodily injury. In this case, it is obvious that this low-speed fender bender, which clearly caused no injuries to anyone, which was Dondi Nelson's fault, could not possibly be Freeman using deadly force.
To your knowledge, did Deputy Nelson require any kind of medical treatment, ambulance, anything of that sort? Okay.
So those are the top 5 lies, but they're just the most obvious lies. Boykin definitely told other lies as well. On April 23rd, 2026, the Court of Appeals handed down their decision, and their decision is that the application is denied. That's right, the Georgia Court of Appeals denied the application, so they're not even willing to hear the case. They won't look at any of the evidence, they won't hear any arguments. Clearly, no one in a robe is going to solve this problem. It's up to the people to solve it. It's been 22 months since the Home Depot released security video, undeniably showing that Freeman did not try to back over Dondi Nelson, but Freeman is still facing an assault charge accusing that he did. That's the kind of foolishness you can't make up. I'm Mr. Pipsqueak signing off, and remember, you should never talk to police without your parents and a lawyer present.